Hey everyone, and welcome to This Explainer. Today, we're diving into a topic that's incredibly fascinating and honestly a bit eye-opening. We're looking at the structural evolution of involuntary servitude. To really unpack this hidden blueprint, a legal architecture connecting 1865 all the way to right now, I want to start us off with a bit of an economic mystery. Think about this. What actually happens to a regional economy when 15% of its entire national wealth just vanishes overnight? Seriously, imagine the sheer scale of that shock. At the end of the Civil War in 1865, the uncompensated emancipation of 3.5 million enslaved people was obviously a monumental, long overdue milestone for human rights. But if we look at it from a purely macroeconomic perspective, for the Southern agricultural oligarchy, it was an immediate and total crisis. Their entire capital asset base was literally completely wiped out.
To put that into perspective, economic historians estimate that Southern planters held roughly $3 billion invested in enslaved human assets. That was about 12 to 15% of all real wealth in the U.S. at the time. Gone. Evaporated in an instant. And because cotton made up 2/3 of American exports, these plantation owners were suddenly left with absolutely zero liquid capital to pay competitive free market wages. So, staring down total financial ruin, the elite class had to find a new way to secure cheap labor. And spoiler alert, they didn't rely on the free market to do it, they relied on the law.
Which brings us right to the 13th Amendment. Now, we all know it abolished slavery, but take a close look at this absolutely crucial, highly exploitable structural loophole embedded right there in the text, except as a punishment for crime whereof the party shall have been duly convicted. The Southern political establishment essentially treated this clause like a legal software update. By systematically targeting and arresting the newly emancipated black population, the state figured out they could legally reduce free citizens back into a state of forced labor simply by reclassifying them as criminals. And you'll see just how incredibly fast this pivot happened. Almost immediately in 1865, states started passing black codes and these massive, sweeping vagrancy laws. Take Mississippi, for example. If you didn't have written proof of a long-term labor contract, you were instantly deemed a vagrant, arrested, and fined. When impoverished freedmen obviously couldn't pay that fine, local sheriffs would legally lease them right back out to private employers, which tragically were often their former enslavers. By 1866, Tennessee was actively leasing convicts to generate state revenue. And by 1884, one single corporation, the Tennessee Coal, Iron, and Railroad Company, or TCI, had secured a total, unquestioned monopoly over the entire Tennessee penal system. The sheer scale of that corporate extraction, it was massive. TCI employed a staggering 60% of the state's entire prison population as miners. They forced leased convicts into coal mines and coke ovens under absolutely deadly, subhuman conditions. And people were being funneled into these mines under the most petty statutes imaginable, like Tennessee's notorious zebra law, where a man could literally be put in prison stripes for something as minor as stealing a single fence rail. It was a highly profitable, entirely captive labor force, supplied directly by the state. Now, this historical reality of convict leasing is really well documented, right? It's pretty universally accepted history. But it leads us to a really important and honestly kind of uncomfortable question. Did this system of corporate carceral extraction actually end in the 19th century? Or did the legal machinery just get another update? I invite you to keep an open mind here as we start looking for the echoes of this exact system in our modern era. Part 1. Criminalizing modern homelessness. To really understand the modern landscape, we have to look at the legal cartography of how status is criminalized today. And this legal architecture just took a major turn with a landmark Supreme Court ruling in June 2024. The case was City of Grants Pass v. Johnson. In a 6-3 decision, the court ruled that cities can legally enforce bans on public camping or sleeping against unhoused individuals, even if there are literally zero shelter beds available. Justice Gorsuch, writing for the majority, relied on this strict legal distinction between status and conduct. He argued that the city isn't criminalizing the status of being homeless, rather it's penalizing the conduct of sleeping outside with a blanket. Now, the dissenting justices, led by Justice Sotomayor, pointed out that if you have no home, the biological necessity of sleeping with a blanket is completely inseparable from your status of being unhoused. By focusing only on the conduct, this ruling effectively immunizes the penalization of poverty from constitutional scrutiny. Now, this ruling absolutely did not happen in a vacuum. The momentum behind it is highly coordinated.
Well-funded think tanks like the Cicero Institute have essentially taken the logic of this ruling and turned it into template legislation. They call it the Reducing Street Homelessness Act. This model bill pushes for statewide camping bans. It diverts funds away from permanent housing, pushes for mandatory involuntary commitments, and get this, it even financially penalizes cities that refuse to aggressively arrest people for public camping. Through networks like ALEC, the American Legislative Exchange Council, these exact policies are rapidly becoming law across multiple states as we speak.
Notice how this builds historically. Back in 1865, the Mississippi Vagrancy Act required freedmen to carry written proof of employment or they'd face arrest. Flash forward to today. The 2024 Kentucky Unlawful Camping Statute, House Bill 5, makes it a crime to sleep outside with a sleeping bag, which can result in up to 90 days in jail for repeat offenses. In both of these cases, the state is utilizing its police power to penalize an unavoidable state of poverty. The structural parallel is pretty hard to ignore.
Let's look at the blueprint laid out here. The connections are striking. In 1865 Mississippi, the target was freedmen, the penalized behavior was lacking a labor contract, and the economic result was supplying cheap agricultural labor. Today, in places like Florida, Utah, and Kentucky, the target is the unhoused. The penalized behavior is public sleeping, and the result is funneling people into state camps or county jails where they become part of the carceral labor pool. So yes, the populations and the specific behaviors have updated, but the underlying legal blueprint of exclusion and extraction, it remains remarkably identical.
Part 2. The carceral supply chain. Which brings us to the next vital piece of this puzzle. Once individuals are funneled into the justice system through these statutes, what actually happens to their labor? Well, it feeds directly into a highly profitable, multi-billion-dollar industrial and agricultural grid. A massive 2-year investigation by the Associated Press tracked this exact supply chain. They uncovered over $200 million in direct sales of farmed goods and livestock grown by U.S. prisoners over just a 6-year period. And understand, that is a highly conservative estimate. That doesn't even include indirect sales, subcontracted labor, or all the goods states procure for themselves. In many southern states, these incarcerated workers are harvesting crops and raising livestock for literal pennies an hour, or in some states, absolutely nothing at all. And where exactly does that $200 million worth of food end up? Right into the supply chains of brands we all recognize and use. The AP traced prison-raised cattle and crops directly to agricultural giants like Cargill and Tyson Foods. Those products then make their way into the supply chains of McDonald's, Burger King, Coca-Cola, General Mills, and massive retailers like Walmart and Target. We're not talking about some fringe operation here. This is deeply, deeply embedded in the consumer goods we interact with every single day. And it's not just agriculture either. On the federal level, you have Unicor, which is a government-owned corporation right within the Bureau of Prisons. Federal inmates are legally required to work if they are physically able, manufacturing things like military gear for the Department of Defense, and they earn between 23 cents and $1.15 an hour. On the state level, there's a program called PICP that allows state prisons to form joint ventures with private companies. And here's the kicker. Even if they theoretically pay prevailing wages, states are legally allowed to deduct up to 80% of the inmate's paycheck for room, board, and taxes. Part 3. Economics of forced labor. To truly grasp why this system is so incredibly persistent, we really just need to look at basic business economics. The fundamental objective of any major enterprise is simple, right? Lower your overhead and your labor costs as much as humanly possible. Labor is almost always one of the biggest expenses for any business. If you can minimize that variable cost, your profit margins naturally grow. Now, in a normal free market, employers have to pay a worker at least enough to cover their basic food, housing, and healthcare. But here is the dark economic genius of the carceral state. The state steps in and absorbs those basic survival fixed costs using taxpayer money. Because the state is paying to house and feed the worker via the prison system, the corporate partner can extract maximum surplus value from their labor. Ultimately, shifting the basic reproduction cost of human survival onto the taxpayers creates the ultimate absolute zero labor cost model. When the taxpayer funds the prison, the corporation's profit margins just skyrocket. Whether it's taking an 80% cut of a state paycheck or paying 23 cents an hour at the federal level, the math is completely undeniable. It elegantly solves a fundamental economic hurdle for private industry. Which leaves us with this final, somewhat provocative thought to take away. We constantly hear that the criminal justice system or the housing crisis are these broken systems in desperate need of reform. But when we trace these legal software updates from 1865 all the way to the modern day, from vagrancy laws to public camping bans, from convict leasing to billion-dollar corporate supply chains, we really have to ask ourselves, if a system elegantly solves a fundamental economic contradiction for corporate capital, is it actually broken? Or is it a highly sophisticated apparatus working exactly as intended? Thank you so much for joining me for this explainer. Keep questioning, keep learning, and I'll see you next time.